The hearing will start now.
Thank you.
This is originating application numbers 381 to 385 of 2022, Zipmex Company Limited and other matters.
All right, good afternoon, Mr. Tang and Ms. Charlene Wee, correct?
Yes, Your Honor. Good afternoon.
I understand you've got a bit of a lost voice. All right, we'll just try to struggle as much as we can. All right. Let me and Mr. Zoom allocation parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. Only those counsel or persons notified to the court should be present in each location. The party should treat these proceedings as they would a physical hearing. All right, Mr. Tang, it's your application.
Thank you, Your Honor. These are the applications in summonses 2291. I'll try and speak a bit louder, Your Honor, at some personal
That's
cost.
all right, that's fine, thank you.
2291 to 2295 of 2023, which are the applications for extension of the moratoria. Previously, this hearing, as you know, Your Honor, previously this hearing was also for the applications for leave to convene, but pursuant to the court's correspondence, we are grateful that those two applications have been adjourned to a date in September, Your Honor.
All right.
So, for matters coming up for hearing today, Your Honor, we will be seeking a bridging moratorium until the date when the applications for leave to convene may be heard. Your Honor would have seen a batch of bundles that have been delivered to Your Honor's office. This includes a bundle of documents, a bundle of authorities, and joint written submissions relating to extension of time. Would Your Honor have them?
Yes, could you summarize briefly without having to go into too much detail perhaps, but just for the record, what is it that necessitates really the postponement of the application for the convening of the meeting?
Yes, Your Honor. So very briefly, we had proposed two schemes previously. The core component of these two schemes were a delineation in the voting rights of creditors. So there was a category A class for creditors under USD 2,500 and a category B class for every other creditor who was above USD 2,500 in value, right? The distribution for these creditors would have been different. Both classes would have received a distribution of what we thought was up to 5.13% in a first tranche distribution. And then the category A creditors would have then fallen away, and the category B creditors would have waited for recovery from Babel's restructuring, as well as any recovery from proceedings against the investor, and then they'll be paid that out at a later date, which we said would be, and we still project to be between 1 to 2 years from the date the schemes become effective. Now, back to Your Honor's question on what necessitated this request for an adjournment. In the interim time between when we filed the applications with the proposed schemes, and as Your Honor can see from the second and third affidavits filed by Marcus Lim in OA381-385, there have been some adjustments to the numbers. First, instead of a 5.13% payout, as we originally thought, it turns out that we can only secure 6 million USD for the sale of the Thai entity and 1 million USD for the sale of the Indonesian entity. This brings us to the very low end of our original projection, which was 7 to 10 million for the sale of both. Given that, the projection now for the category A creditors has diminished from 5.13% to 3.35%. At the same time, there's also a development in terms of the potential recovery that we can get from Babel. Your Honor will know that in July, Babel released a restructuring term sheet to creditors. It was a bunch of slides, actually. And based on our calculations on what we understand to be the outstanding that we will prove for in Babel's restructuring, the Zipmex group stands to gain between 29% to 68% of that particular debt in Babel's restructuring. This brings us to a total potential recovery to creditors of what was formerly only category B creditors of between 14.24% to 29.35%, low to high, Your Honor. And we should also stress that these numbers don't take into account any recovery from the investor. So because of these changes to the numbers, we have reconsidered the creditor structuring. We believe now that a 1% to 3.35% recovery is not very palatable. The 1.64% being a liquidation scenario and the 3.35% being the original payout if we were to maintain this particular creditor structure. And so we are proposing a new creditor structure in which all creditors will be invited to share in the proceeds of the Babel recovery and the recovery from the investor. There are logistical difficulties to this. And so as a counterpoint to this, what we are instead now proposing is that instead of a cash distribution for these recoveries, the latter recoveries, we will be distributing them in USDC. Administratively, that would save a lot on bank charges because bank charges internationally, our estimate, I can't be sure, but our estimate is approximately $50. And any distribution falling under that will not be worth, it'll be a loss to the company to send it out. So that's the first part. So this has resulted in a shift from us in that any recoveries from Babel and the investor will be converted to USDC and then distributed. And the second thing that we will make clear in the schemes, Your Honor, is that for every distribution in which the amount to be distributed does not exceed the administrative costs, the creditor will hopefully vote on and agree to waive its right to that particular distribution. Again, this is for administrative cost purposes, Your Honor. But other than that, our belief is that by so increasing the potential number of creditors that will be eligible for distribution, it makes it more palatable, it makes it more egalitarian, and it makes it more equitable to all creditors who can then participate in the schemes as a whole, instead of having that double-tiered structure as we originally proposed. And that, in a nutshell, Your Honor, that is why we have requested for the adjournment.
And thus the extension is only for that reason as well?
The extension is...
Sorry?
No, Your Honor. The extension that we are requesting now is a bridging moratorium until the applications for leave to convene to maintain the status quo for all the 5 companies until then.
All right. I had indicated, Mr. Tang, at the last hearing that I would need a strong reason to grant further adjournments unless the scheme is imminent. Are you able to say hand on heart it is imminent?
Yes, Your Honor. I mean, if we were to look at the history of the filings, Your Honor, we did file, we did prepare and file the schemes within the timelines that we had previously indicated. This, I appreciate, is a minor return to the drawing board, but it's not it is not a fact that we will have to rewrite the entire schemes. Actually, there are small changes that need to be made to particular portions of the draft schemes, but the majority is there and can be easily amended, Your Honor. We also note the timelines and the correspondence from courts, and we are prepared, and I can say, as Your Honor has asked me to say hand on heart, that we are able to do so within the timelines. The only issue, Your Honor, is the date of the hearing itself, on which I had written to court in my personal capacity to request for a slight shift in the date of the hearing of 18 September.
Right.
I'm not sure if
we can work out. I can give you another date soon after, but I really need to underline, Mr. Tang, for yourself and everyone involved that whatever the reason might be, I don't want a situation where we have a creeping extension after creeping extension and people push it back bit by bit. I think there has to be some resolution. by October latest. All right. I would really like to see this move to a vote before the end of the year.
Yes, Your Honor. We appreciate the court sentiment on this, Your Honor. And I think the court can rest assured that it is not our intention at all to have any such creeping extensions. I think, as Your Honor may appreciate, this is actually the first time that such a creeping extension has come up in these proceedings, Your Honor.
All right. All right, you have an email. I don't know whether you received it. There was an email sent in by one of the creditors concerned about the previous exposure, and really, let me see how best to summarize it. To explain, basically, there's a missing portion of the funds from the Z Wallet funds, and there are concerns about what has happened to the money and whether there's an inappropriate use of funds. Basically, that the FAQs may not actually be, the FAQs may not have actually answered the queries, and that there are other questions arising. Have you seen that email?
Yes, Your Honor. We received a copy from Ms. Kwang.
Are you able to respond right now, or would you need to put up an answer in some other way?
Your Honor, I can respond now with client's instructions on short notice. Probably a more detailed explanation will follow in an affidavit.
All right.
What I can say to the creditor in question now, and I'm not sure if he's in attendance.
Yes.
Is I should probably go into a bit of an explanation on the deployments between the Babel Group and the Zipmex Group.
All right.
So what has happened, Your Honor, is that as between entities in the Babel Group and the Zipmex Group, the Zipmex Group had deployed a total of 1,730 Bitcoin, 11,530 ETH, and 14.5 million USDC. So that is what the Zipmex Group extended to the Babel Group. Flowing the other way, an entity from the Babel Group extended towards Zipmex Private Limited a total of 24 million USDT. This was on or around June 2022. And that's the 24 million loan which the creditor is referring to in the email. What this has resulted in is a net exposure to Babel of approximately USD 48 million. That is approximately, again, the amount that the Zipmex entities will be proving in Babel's in Babel's restructuring, and which should form part of the recovery under the proposed schemes. As to the creditor's question on what was done with this 24 million, at the time when this money came in, the Zipmex Group was still operational. In fact, it remained operational until very recently, Your Honor, when the investor put out the SSA. The 24 million was applied. My instructions are, it was applied towards all sorts of expenses, including salaries, including staking, and the operational expenses of the group. That's the best response that I can give right now on short notice, Your Honor. And these are my client's instructions. All right.
And you'll be able to put a fuller explanation in a affidavit?
I believe so. Your Honor, since we are due to file a further affidavit in any case, because of the revised schemes, I propose that we include a section on this particular query there.
All right. And could this answer also be put up through your other channels with the investors?
Yes, Your Honor. As per, sorry, other channels as to the
I mean, I can't remember offhand what channels you have with the investors. I don't think you don't have a WhatsApp group, correct?
Creditors, Your Honor.
Yes, for the investors, I mean. To the account holders.
To the account holders, okay. Well, Your Honor, yes. For every paper that is filed, Cordamenta, the scheme manager, sends a personalized email to every creditor on record.
All right. Could a copy of it be sent around in the same way?
Yes, Your Honor. For sure.
All right. Into your communication channels with the account holders, right?
Yes, Your Honor.
All right.
Your Honor,
Mm-hmm.
there is one further issue that we had raised in the second affidavit of Marcus Lim,
Mm-hmm.
which is in regards to the question of sealing
Mm-hmm.
and the investor's identity. Would Your Honor wish me to take you to the specific paragraphs?
All right, but you're asking for sealing of, could you just summarize your application right now in terms of sealing?
Right. Previously, a seal was granted
Mm-hmm.
over the investor's identity as well as the other identities of the
Mm-hmm.
parties to the SSA.
Mm-hmm.
The investor's reason at the time was because it didn't want public pressure to influence its decision whether or not to proceed the transaction. We had previously raised this. Our view was that this objection is no longer valid. Your Honor had asked the investor to write in. The investor wrote to MLS. We sent a copy of the letter to the court. Unfortunately, that we didn't follow up on that in further hearings, Your Honor. Right now, in the second affidavit of Marcus Lim in OA381-385, Your Honor would have seen extracts from a group chat titled Victim Zipmex. These are, would Your Honor like me to bring you to the...
All right, hold on. Yes.
Yeah.
Mm-hmm.
So it's the bundle of documents. Perhaps if I can take Your Honor to the paragraph in the affidavit. This is paragraph 58 at page 239 of the physical BOD.
All right, page 239, all right. Carry on.
Right, so page 239 starts at paragraph 58. And Your Honor will see at paragraph 60, Marcus says that he has been provided with transcripts from the group chat. At 61, Your Honor will see extracts, right? Apparently, some customer creditors are concerned that the SSA was a fake deal. At subsection C, basically it's a scam since the beginning. Zipmex commits fraud against the people. Yeah, so these are the relevant extracts, but essentially what they are saying in the group chat is based upon the fact that because of the sealing order, all we have ever shown creditors of the company, or all we have ever told creditors of the company, is that the SSA exists. We believe that this belief is perpetrated because they have never seen a copy of the SSA. In fact, the affidavit, which has a copy of the SSA, is presently under seal. What we propose to do, if Your Honor is with us on unmasking the investor's identity, is that we will, soon after this hearing, file a further affidavit, distribute it to all concerned, with a copy of the SSA that redacts the other parties' identities, but takes out the redactions insofar as they relate to the investor. So it's basically the 13th affidavit of Marcus Lim, but with some unredacted redactions.
All right. Could you remind me, there was correspondence from the law firm acting for the investor, correct?
Yes, there was, Your Honor.
All right. What date was that again, sorry?
It was 3rd May. I believe that we also filed that letter on 3rd May. It should be in the affidavit itself, and I'm just looking for the page reference for Your Honor. Charlene, do you have it on hand? Right, so page 274 of the BOD. So it's exhibit ML8.
All right.
This is a letter from Morgan Lewis Stamford dated 3rd May. At page 275, you will see at paragraph 2, page 275 is a letter from Raja and Tan, who act for the investor.
Yes.
At paragraph 2, our clients take no position on the Honorable Court's query on the lifting of the sealing order.
So just confirm the R&T on behalf of the investor has indicated that no position is taken. All right. Because of the circumstances. All right then. Right, so you're asking for the sealing order to be lifted as to the identity of the investor, correct?
Yes, Your Honor.
All right. All right. All right, I'll come to that later. But then you propose to have an affidavit filed, and it's also going to be distributed to the credit. I should use the right term. To the account holders, correct?
To all creditors, Your Honor, not just the
Okay.
accountants.
So, all right. All right then. All right, I'll come to that in a bit, but let me give you the directions for the hearing. All right, so Mr. Tang, just to bear in mind that there's to be no creeping extension after extension. We have to bring this to an end, and I would really, really hope to see by the next hearing the application to convene the meeting.
Yes, Your Honor. Your Honor, before you give the directions in respect of the summonses, perhaps I have one administrative suggestion to make, if this is not too forward. My suggestion would be that the court exercises its discretion to extend the moratorium for 1 month and adjourns these hearings of summonses 2291 to 2295 to be heard on 18 September 2023 or the same date as the leave to convene applications. This would save us the cost, Your Honor, of filing 5 further applications for extension of the moratorium, which is what we would have to do if we want the further extensions, because we need more time to convene the meetings of the...
No. That is too forward, Mr. Tang.
Understood.
All right. I'm not going to relieve the company of that. All right.
Understood, yeah.
All right.
In which case, at paragraph 36, page 16 of my written submissions, we have proposed alternative wording for each of the summonses. So it's the final page, just before our signature.
All right, hold on a moment. Right. I'll grant the extension to the 29th of September, and I'll leave you to amend the specific order accordingly, but it can be in the same form as what you have at paragraph 36.
Thank you, Your Honor.
So I would expect by the 29th of September that you will have filed the convening application. So when can I see the affidavit and application come in?
Your Honor had granted timelines in the correspondence from courts. We will follow those timelines, Your Honor. I believe that it is 4th September. I believe so.
All right.
In the correspondence.
All right, so you can follow what we've conveyed, all right? You confirm that?
Yes. It's 4th September, Your Honor.
All
yes.
Right. So as per the letter, you have to file it by the 4th of September. 2023, sorry, all the application and affidavits will be filed by 4th of September. All right?
Yes.
All right, just to avoidance of doubt, the affidavit should address the matters raised today. All right?
Yes.
Right, so again, I reiterate it, there shouldn't be any further applications for extension unless something really major onto what has happened. There shouldn't be any further tweaking of this, and we really need to come to a resolution, and the investors need to be allowed to vote it up or down. All right.
Understood.
So I will expect to see the application to convene the meeting filed ahead of the 29th of September. All right, Mr. Tang?
Yes, Your Honor. Save that the applications have been filed, Your Honor. It's just revised schemes.
All right, but whatever it is, whether no further minor revisions, I expect everything to be lined up. That's what I need.
Yes, Your Honor.
Be able to do that, Mr. Tang?
Of course.
All right. Expect no further revisions. All right, so sealing as to identity of investor is lifted. Anything else you need from me this evening?
Nothing from our side, Your Honor. Thank you for the court's time.
Hold on, let me just make sure everything's been covered. All right.
Apologies, Your Honor. One thing just occurred to me. The new hearing date for the leave to convene.
Yes. I've not 29th September, 4 p.m.
29th September, 4 p.m.
Yes. 2023, 4 p.m.
Would there therefore be any amendments to the directions and the deadlines?
That's what I was asking. So given 29th September, I thought that was what you said you're comfortable with that?
We are comfortable, Your Honor. Of course, more time is more comfortable, but it's fine either way. Yeah.
All right, because it's 4th September, you should be fine ahead of time, correct?
We should, yes.
All right. So for hearing on the 29th of September, 4 p.m. Do you want me to send you to an AR to work out the various timelines? I don't think that's necessary, Mr. Tang.
No, I don't believe it's necessary, Your Honor.
All right, so you'll be able to file everything on the 4th of September ahead of the 29th of September?
Yes. So just to clarify the timelines with the court.
Yes.
The correspondence does say our affidavits to be in by 4th September, 4 p.m.
Yes.
Reply affidavits to be in by 11 September, 4 p.m.
Yes.
Return submissions by 14 September, 4 p.m.
Yes.
Presumably, all this was premised on 18 September.
Yes, correct.
Hearing, Your Honor. So if there's any change,
you want more time then?
Sure, Your Honor. If
so, when can you send it in then? If I'm seeing you on the 29th, what would you propose?
Okay, let me work backwards, Your Honor. If you're seeing me on the 29th, perhaps written submissions by the 26th of September.
Yeah, affidavit remains as 4th September.
Working backwards. Working backwards. Written submissions by the 26th of.
No, I meant for can the affidavits remain on 4th September? I'd like the investors to have a bit more time to digest.
Sure.
All right, so we keep the affidavit to 4th September. I'm willing to give you more time for the submissions.
Sure.
All right.
Okay, 4th September, reply affidavits still by the 11th, and then written submissions by the 25th.
25th. All right, then I'll record it accordingly. 4th September, affidavits, any replies by the 11th of September, and the submissions by the 25th of September. All right? You can work on this basis?
Yes, of course.
All right, then. So see you on the 29th of September for the convening, Section 210 convening application. All right?
Grateful, Your Honor.
Hold on, let me just check if there's anything else. All right, I think in the interest of transparency, although there's a personal nature in relation to the request for the dates in question, you have a suitably redacted version of why the 18th is not suitable?
I don't have it on hand, but what I propose to do is to request the entire portion for the to redact the entire portion dealing with my personal circumstances.
All right.
Yeah.
All right. So can I just record it for anyone watching these proceedings that originally we had looked at the 18th of September, a request, but that for various personal reasons which are not germane to the proceedings, we are not able to proceed with the 18th.
Thank you, Your Honor.
All right. All right then. All right. Anything else, Mr. Tang?
Nothing from us, Your Honor.
All right then. So let's keep to this, and I hope we will I'll be able to order or at least consider, or one way or the other, the convening or dismissal of the application to convene by the 29th of September. All right?
We praise Your Honor. Grateful.
All right. Thank you.
Thank you.
All right. I think that's all then. Court is adjourned.
Good day, Your Honor.
Good day.
Okay.